Paul, you may proceed with the program.
Hi, everyone. I'm glad to be here today to talk to you about transatlantic privacy. We are going to be comparing the state of US privacy laws with the EU privacy laws. We will be recording this session. In fact, I think the recording has already begun. If we want this session as well to be as interactive as possible. So if you have any question on anything, please pop them into the chat window. So I am Paul Lenoir. I am a director at the law firm Fisher. I am based in the Silicon Valley, and I advise clients in relation to data protection and cybersecurity law. I've been at Fisher for a few years now. Before that, I was working in-house. I was with Credit Suisse, working in Switzerland and in the Hong Kong office. I've also worked at law firms in London and in the Luxembourg as well before. So the topic of cross-border data, international requirements, and so forth is a topic which is extremely familiar to me. And then we have on this webinar as well, we have Richard Lawn. Richard, would you introduce yourself?
Yeah, absolutely. Hi, everyone. So my name is Richard Lawn. I'm a senior associate at Fisher. I originally trained and was working in the UK for a few years, and then I moved out to the US almost 4 years ago and have been working in the Bay Area, predominantly working with US clients, considering European and US data protection issues, including issues around transatlantic privacy and international transfers.
Excellent. So you have our contact info on this slide, and without further ado, let's begin. So if we move on to the next slide, the agenda. We're going to be talking about these topics today. So we'll first do a quick overview of the current state of US and EU privacy laws. Then we'll be talking, of course, about data transfers, which is another hot topic at the moment with lots of new developments in this area. And then looking a bit into the crystal ball, we'll be talking about the future, or what is what we expect to be the future of transatlantic privacy. Okay, then. So let's begin. So as I mentioned, the topic of privacy laws is a topic which is which appeals a lot in the news. It has been in the headlines quite a bit. So you can see on this slide here, just a sample of some of the headlines which have made the news over the past couple of months. There's been a lot of news about enforcement actions, privacy fines, and so forth, coming from the EU, decisions from data protection authorities, which have impacted quite a number of companies, for example, in relation to the use of analytic solutions and so forth. So it is definitely a topic which is getting an increasing amount of regulatory scrutiny. So if we move on to the to the next slide, so here is really at a super high level, some of the key differences between the European framework and the US and the US framework. So in the United States, for example, there isn't any comprehensive, broad federal privacy law which covers all of the different privacy areas. Instead, we have a patchwork of federal sectoral laws covering certain specific areas, and then in those areas which are not covered, we have state privacy laws as well, for example, in California and so forth. In the European Union, on the other hand, you have a comprehensive regulation. You have the European General Data Protection Regulation, the GDPR, which provides a harmonized set of rules across the EU. But then it doesn't mean that you have only one single piece of legislation to consider in the EU, because, for example, in some areas like cookies, you have to look at another piece of legislation, the e-privacy directive, and then even in relation to topics which are covered by the GDPR, you may have certain variations across the different EU member states as well. So it's the GDPR is a starting point, but it's definitely not the single point of the single legislation in the EU. In terms of rights, you have a strong level of protection, and you have quite a number of different privacy rights as well, which are enumerated under the GDPR. Under the US, you have narrower protection, because you don't necessarily have, as I mentioned earlier, you don't have a single federal legislation which covers all of data protection, and therefore you may have protection only in specific areas, or otherwise only in certain specific states. One of the the reasons why privacy is viewed differently in the EU and in the US is that privacy is considered to be a fundamental human right. It is a fundamental human right in the European Union, and that's the reason why there is a lot of focus, why there is a lot of attachment to privacy in the European Union, whereas in other countries, for example, in the US, because it's not seen exactly in the same way, it is more a consumer protection issue as well. To a certain extent, there may be some, there may be some areas where it's not exactly the case, but here's really the the broad outline. In terms of enforcement, you have enforcement by the different national data protection authorities in the European Union. So you have one for each European country. In some areas, you may have more. For example, in Germany, you have one data protection authority per region. But then, you have globally national data protection authorities, which are there to enforce data protection laws. Whereas in the US, you have a broader, a higher risk of enforcement, because you do have different authorities, different legislations, state enforcement as well, and you do have quite a number of class action lawsuits as well, which we'll talk about in a bit. Moving on to the next slide, Richard.
Yeah, thank you, Paul. So that just gives a broad brush overview of some of the key differences between the approach in Europe and the EU and the approach in the US. But now we're going to do a bit of a deeper dive on the principal laws and the current state of play in both of the jurisdictions. So we're going to start with the EU and look at the General Data Protection Regulation, the GDPR. You probably heard of this law. It was a blockbuster law when it came into effect in 2018. We're almost at the 5-year anniversary. And really, we've seen the GDPR having a huge impact within the EU itself, but also having an impact further afield, including for non-European businesses that are looking to offer services within the EU or are looking to provide services to customers that are impacted by European regulation. But also we're seeing its impact kind of on a legislative level, because countries around the world have looked to the GDPR as a possible model for adopting their own rules and regulations within their own jurisdiction. So what is the GDPR? Well, it established a general framework for the processing of personal data. So unlike the approach in the US, here we have a single kind of harmonized approach, establishing a baseline set of rules. We're not concerned with a specific type of data or specific industry or type of provider. It's instead a general framework that applies in all sorts of use cases. There's also no de minimis threshold. So actually, this applies to all ranges of businesses, whether we're looking at big tech and the very largest platforms and providers, or whether we're looking at SMEs and startups. So very broad and all-encompassing. Paul mentioned earlier that although the GDPR establishes a kind of baseline for protections in the EU, there are some additional rules that you might need to consider at the national level. You know, the EU is comprised of 27 member states, and in some areas, countries are left to their own devices to interpret and apply certain areas of the law, but also certain countries might introduce new additional rules that go above and beyond what the GDPR requires as well. So although we kind of have this broadly harmonized approach, there are naturally some differences in local rules as well that sometimes need to be taken into account. In terms of the scope of the law, so as I mentioned, it applies not only to organizations that are actually established in the EU, but it applies to organizations that either offer products or services in the EU or that monitor the behavior of EU data subjects. So if you're a US provider or you're otherwise outside of the EU, the GDPR actually has extraterritorial effect, and it can still apply to you directly because of these two limbs here, B and C. And that's really why, one of the reasons why the GDPR has had such a big impact globally, because so many companies have touch points with the EU. The GDPR is enforced by individual data protection authorities within the various member states. So each member state will have their own data protection authority. For instance, in France, it's the CNIL. In Italy, it's the Garante. In Germany, actually, that's on a regional basis. So I think there's about 16 separate DPAs depending on the region in Germany. And they are competent to enforce the GDPR within their jurisdiction. But there's also kind of this coordinated approach. So the GDPR has a mechanism called one-stop shop. And effectively, that means for any cross-border processing, a lead authority basically can act as the enforcer for particular activity. So for instance, if you are a US provider and you're offering services in the EU, you're processing the personal data of people in France, Germany, Italy, Spain, across multiple countries, then in theory you should have one lead authority that can potentially take action and enforce the GDPR against you, and the various data protection authorities should coordinate in that effort. The one-stop shop doesn't always apply, and it isn't always necessarily operating perfectly or effectively. So there are some questions about updating that model, but at least in principle, there should be some kind of coordinated effort around enforcement of the GDPR across the EU. In terms of the consequences, well, you probably seen and heard that fines can be pretty big. So up to 4% of global revenue in some cases. We haven't actually seen fines being issued at that 4% level, but even at lower percentage levels, they can still become quite high. I mean, the highest GDPR fine to date was issued by the Luxembourg DPA, actually, and that was against Amazon. We don't have the details of that case yet, but we know that it was a fine for around, over $880 million, roughly, and it related to digital advertising and Amazon's use of first-party user data for targeted advertising purposes. So that just gives you a flavor of the level of fines that we're talking about under the GDPR. In addition to the black letter law, we also have guidance and codes of practice that are issued by the DPAs, as well as a body that's called the European Data Protection Board, which is an independent body made up of representatives from all of the member states. Now, some of the guidance is actually non-binding, but some codes of practices can be binding. So, for instance, France has issued some binding codes of practice. The UK, while it was still part of the EU, issued also its own binding codes of practices in particular domains as well. And lastly, to mention here, we're talking about the EU. UK and Switzerland are not part of the EU, and therefore they have their own data protection regimes. So following Brexit, the UK actually incorporated the GDPR into domestic law and gave it the very imaginative title of the UK GDPR. So at the present, the rules for the UK are roughly equivalent because they haven't done too much to change the rules. But in the future, that might change as the UK looks to reform its own domestic data protection rules. And then in Switzerland, we don't have the GDPR, but we do have the Swiss Federal Act on Data Protection. And it's just worth noting that actually Switzerland has just updating that act, and later this year those updates are going to take effect, and they're basically going to introduce new requirements and protections. But the GDPR is not the end of the story in terms of European data protection regulation. So the other kind of blockbuster law in the EU is the e-privacy directive. And this is not concerned specifically with personal data. Here, this is concerned about privacy in the context of electronic communications, and where we're interacting with online services and telecommunications providers. So this only becomes relevant in certain contexts. Principally, many of the rules apply to telecoms providers. So that could be your traditional telcos that are providing telephone services or other kind of communication services. But now it also applies to more modern kind of telco services, over the top services, where people are sending instant messages and things like that using electronic communications networks. But it's also worth noting that there are some rules in there, quite important rules around, firstly, the use of cookies and similar tracking technologies, and secondly, around direct marketing, where that marketing is sent by email, SMS, and other electronic means. And those rules have a much wider scope in terms of who they apply to. So they don't just apply to certain industry, they effectively apply to anybody who's implementing tracking technologies on their website or on their mobile app, and anybody who's engaged in sending direct marketing to people who are based and residing in the EU. So a lot of the time when we're working with clients, we might be working with clients who are providing telecommunications services, but more commonly we're looking at these rules around cookies and direct marketing because they apply to a much broader range of businesses. An important point to make about the e-privacy directive is that it's a directive, not a regulation. And in terms of European lawmaking, a directive doesn't have direct effect across all of the EU. Instead, what happens is that individual member states need to implement those rules within their own national law. And what that can mean is that actually there are different standards and different implementations according to the member states. So it really depends on how the country has chosen to implement those rules under its national law. And that's where we start to see some variations and a move away from the ideal harmonized approach. So that's not only the case in terms of what the actual rules say around the use of cookies, direct marketing, etc., but also the case in terms of the level of fines and the consequences, because again, they're set at the national level and they can vary quite a lot. So that just gives you an overview of the two main laws in the European Union around data protection. Don't forget, that's not the be-all and end-all, but for the purposes of this webinar, we just wanted to focus on the two principal laws. But I'll hand back over to you now, Paul, and we can take a look at the landscape in the US.
Thanks, Richard. I'm not going to spend too much time because I'm assuming as well that most of you are already familiar with the privacy framework in the US. And anyway, the information is on the slide as well. So you do have quite a number of different federal laws which cover specific areas. For example, in the area of financial institutions, in the area of health-related information, children as well. You can see as well the topics which are the most important, parties which are seen as being particularly vulnerable for the legislator, which deserve a specific protection. Communication as well is an area where you do have federal laws, and generally speaking as well, you do have the FTC Act, which allows the FTC to take action whenever it considers that there is any unfair or deceptive practice. And this has actually led to quite a number of privacy enforcement cases as well. Some of the biggest fines as well, which have been imposed in the US come from the FTC. I'm thinking especially in relation to social media companies. Just last week as well, there was a notice by the FTC that they were going to be taking further enforcement action against a social media company. So it is. Yeah, I would definitely say that even though you don't necessarily have a comprehensive federal privacy law in the US, it doesn't mean that there is no enforcement at all. It's quite the contrary. You do see quite a lot of enforcement by the FTC as well. And beyond the federal laws, you do have as well state laws. So moving on to the next slide, you do have quite a number of different state laws which are in place. So here is a list. It's not an exhaustive list because the list keeps on expanding, and this are just some select examples. So in terms of breach notification laws, you now have all of the different states who have implemented a data breach notification law. Just a couple of years ago, it wasn't the case, but then now you have all of the states who have implemented one. Health and biometric data, you have quite a lot of attention, I would say, which has been given to Illinois because you have the BIPA, the Biometric Information Privacy Act, which has given rise to in lots of litigation, I would say, in this area. Washington has recently introduced the My Health, My Data Act, which is quite extensive as well in relation to health-related data and any data which may be more or less connected as well to health data. So it is something to be mindful of in the future. And then children's privacy, I mentioned earlier, you have COPA at the federal level, but then at the state level, you have the California Age-Appropriate Design Code Act, which was recently introduced. It will come into effect in about a year's time. And it does mirror as well the UK Age-Appropriate Design Code. Even the name is similar, and they do as well mention as well in the legislation that it is inspired as well by the UK framework. So it's a topic which has been getting lots of attention. Other states have also been looking at protecting further children's online privacy. So you have Utah, you have Arkansas, and you have other states which are looking into it as well. Data brokerage, you have California data broker law, which is not the same as the CCPA. So you have a different legislation in relation to individuals who are doing a data brokerage as defined by the law. Vermont as well has such a law. And then the most relevant piece of legislation for quite a number of folks would be the different state privacy laws that you have listed here. It's not an exhaustive list as well because you have other state privacy laws which will be coming into effect later on as well. So the first one was the California Consumer Privacy Act, the CCPA, which entered into effect back in 2020, and then it was updated recently with the California Privacy Rights Act, which entered into effect earlier this year in January. And the CPRA, the updated version of the legislation, it increases and it expands the scope of the CCPA and brings it in closer, I would say, to some of the requirements that you have in the EU in certain spaces, and in other areas it could be seen as well as being a bit more extensive because the California law does as well have certain requirements which you don't have in other that you don't have, for example, in the EU in relation to the selling or sharing of personal information, specific disclosures that you have to provide, the specific opt-outs and so forth. You have quite a number of formalities that you have to comply with under California and other state privacy laws. And then you have other state privacy laws which which have either already been enacted or which will come into effect in the near future. So you do have the Virginia Consumer Data Protection Act, which entered into effect in January as well. So it's both California and Virginia's state privacy laws are already in effect. In the near future, you would have Colorado, Connecticut in July, and later on in the year in Utah in December, you would in December of this year, 31st of December, you have the Utah Consumer Privacy Act, which will enter into effect. And then later on as well, you have Indiana Consumer Data Protection Act. Other states are looking as well into it. You have Tennessee and Montana, which are not mentioned here because if I haven't checked today, but then when I checked yesterday, it hasn't yet been signed by the governor. So it's the list of state privacy laws are definitely growing, and this also means that in terms of compliance efforts, it does mean that because the laws are not exactly identical, it does mean that there's going to be the need to focus a lot on the different requirements applicable in each state, and also look at the variations which exist because the requirements are not exactly the same.
Yeah, and as you say, Paul, as a practitioner, I think one of the increasing challenges in privacy is because this landscape is constantly evolving and because of the rapid pace of change. I mean, this list that we've got on screen is representative. It's not the whole list, but there are new laws being added all the time. And it feels like practically every week there's a new announcement that we need to be aware of, whether it's a new law or whether it's new guidance or whether it's a new court decision or enforcement. All of that we need to read, we need to understand, interpret, apply, and keeping abreast of all of these developments, while it's exciting, is also, I think, a particular challenge for privacy practitioners.
Exactly, and because you have so many different privacy laws at the state level as well, there's a lot of talk about a federal privacy law. There was one which was introduced last year, and unfortunately it didn't come to fruition because there was disagreement over the topic of preemption. So it basically that federal law would have preempted the different state privacy laws. So it would have meant that it would have taken away a lot from the CCPA and the other state privacy laws, and that's the reason why you had some states like California and some others as well who are against having a federal law, because they were saying, well, they are fine with the idea of having a federal law in relation to privacy, and that's something to be encouraged. But then their issue was that, well, the federal law shouldn't be setting a ceiling. It shouldn't limit or block the possibility for some states to provide additional protections beyond what the federal law would say. California, for example, was saying, well, they do think that in some areas they may have to provide additional protection, and then they may want to cover as well new technological areas and so forth quicker than having to wait for an update to the federal law. So that was one big sticking point at this topic of preemption, of the fact that it would be introducing a ceiling instead of setting a floor. And there's the reason why the federal law didn't pass last year. And then this year, it is still being discussed. There is still talk about coming up again with a new federal law, especially because the state laws are springing up like mushrooms practically. According to the latest talk as well, is that they're looking into bringing back this federal privacy bill, and they want to add new requirements as well in relation to AI, because obviously AI is a big topic at the moment. Everyone's talking about it, and they've some of the legislators wanted to add some AI related provisions in a proposed federal bill. So let's see whether that actually comes to fruition or not. If we move on to the next, the next slide. So here is some of the different points of the different state privacy laws. This is obviously not an exhaustive list of everything that you have to be mindful of. This is just we've just cherry picked some points. So the effective date, as you can see here, Most of them haven't been haven't entered into effect yet, so you have to wait till July, as I mentioned, and in December for Colorado, Connecticut, and Utah. And the terminology as well is not exactly the same across legislation. So California has its own terminology. It does use the term of business service providers and contractors, which is different from what you have in the GDPR or in the other state privacy laws, which use the traditional concept of controllers and processors. So you do have a bit of convergence in terms of terminology, because they do use some of the same wording as well as the GDPR, except in California. And the reason why California hasn't used exactly the same wording is that they didn't feel that the concept should exactly overlap. So business would more or less match the concept of controller, but then it's not a perfect match. And the same goes for service provider, which would typically match what a processor would be doing, but it's not it's not completely a 100% match as well. The scope as well is quite different, because the nonprofits would be covered, for example, under Colorado and not in the other states. And then if you're dealing with employee data, that would be covered by California law and not by the other state privacy laws. Business-to-business data as well, that's something which is in scope of California now since January of this year, whereas it's exempted under the other state privacy laws. So some of you may have heard that there was an exemption for HR data and B2B data in California, and that was true under the CCPA, but then when the CPRA entered into effect in January of this year, that exemption ended, and therefore you have to to be mindful that HR and B2B data are in scope. Therefore, you need to provide the notices and so forth in relation to such data in order to comply with the CPRA. Private right of action, that is, especially when you have so much litigation going on at the moment, it is an area to be mindful of. And the other, most of the state privacy laws do not provide a right of action in relation to the privacy law. In California as well, you have a limited limited private right of action. So this means that in relation to data breaches, security incidents, you may have the possibility to initiate an action, but then for all of the other situations, you don't have the right to initiate an action in California. This doesn't mean that that individuals can't do anything, because they can, of course, submit a complaint to the Attorney General, or in California to the either to the Attorney General or the California Privacy Protection Agency, and in such cases, well, the Attorney General or the CPPA are able to to initiate an investigation if they want to. Moving on to the next slide. Was there something that you wanted to cover, Richard?
Yeah,
or should I?
Yeah, I'll take this one. That's fine. So, we've talked through a little bit about EU privacy laws and US laws, and this slide really attempts to identify some of the key similarities and differences. These are very high-level statements, so of course there's going to be some exceptions, but we're just trying to point out some of the main areas of similarity and difference. The first is one we've kind of discussed already, which is in terms of scope. That the GDPR as a data protection law has extremely broad scope, whereas US state privacy laws, they generally apply to a narrower range of organizations. And that's not only because they exempt certain types of organizations that are covered under federal statutes, that it might be covered under the Fair Credit Reporting Act, or might be regulated by HIPAA or COPPA or other privacy regulations, but also because of the type of information that might be covered. So, Paul mentioned that in California, HR data and business interactions data is within scope, but actually for all of the other US state privacy laws, that information isn't within scope. So therefore, fewer organizations are actually covered. And obviously the GDPR, as I mentioned earlier, applies across the EU, whereas the state privacy laws only apply if you're actually conducting business within the relevant states. Similarly, the scope of application is determined by this definition of personal information. You know, what's the information that's covered by the rules? Now, the actual baseline definition is pretty, I think it's fair to say, quite similar in terms of the EU and the US. They both are adopting increasingly a broad definition of personal information. But there are some important carve-outs under the US state privacy laws. One notable example is that US state privacy laws generally don't apply to publicly available information. And so therefore they distinguish between data that you might be collected from public records or from the internet or other kind of publicly accessible spaces and information that you are collecting directly or obtaining from third parties. The GDPR doesn't make that kind of distinction, and even publicly available information is within scope. In terms of sensitive personal information, both regimes have particular rules around the collection and use of sensitive personal information. There are some differences in terms of what is considered personal, what is considered sensitive or not. Some of the common ones include things like health data, biometric data, information about, race and ethnic origin. A lot of those, these laws take a common approach and consider them to be sensitive, but there are some other additional ones under US state privacy laws. So just to give you some examples, the CCPA, California's law, it also considers precise geolocation data, certain identification information, account information in combination with a password, and certain communications content. It considers a lot of that data to be sensitive as well. And then in terms of the rules themselves, well, in the EU, generally speaking, it requires consent to collect and process sensitive information, with some exceptions. Whereas in the US, what we're seeing is more of an opt-out model. So the CCPA says that somebody can limit the use of their sensitive information, i.e. they can opt out if you are using that information for purposes that go beyond core permitted purposes under the CCPA. So some important differences there in terms of the approach. Similarly, there are differences in terms of the rights that these laws grant to individuals. There are some common ones, things like the right for individuals to access their personal information, request its deletion, update and correct their information, and the right of data portability. But there are some additional rights under the GDPR and some additional rights under US state privacy laws, which indicate, I think, a slight difference in terms of the priorities and the kind of risks that these laws are attempting to address. So to give you one notable point of difference, US state privacy laws are really concerned with the sale or sharing of personal information for targeted advertising purposes, and they give individuals the ability to opt out from that sale or sharing. That isn't something that's specifically regulated by the GDPR, although obviously some of those rights and principles will be important in the context of selling or sharing information. There isn't a specific right in the same way that the CCPA and other US state privacy laws have. I'll just briefly mention some other ones before moving on. So all of these laws have kind of particular contracting requirements where a controller or business is engaging a processor or service provider to process information on their behalf. I think it's fair to say that the contracting requirements under the GDPR are a little bit more prescriptive and more onerous. They include a broad range of terms that needed to be included in the contract, whereas the US approach is slightly lighter touch, although I think it's fair to say the CCPA is a little bit more strict. I already mentioned opt out from sale and sharing, so targeted advertising it's worth pointing out that targeted advertising is regulated differently in the EU and the US. In the EU, we're not looking just at the GDPR. We also have to think about e-privacy rules around the use of cookies and tracking technologies that effectively enable and facilitate targeted advertising online. So the rules in the EU can be complex and you have to navigate different requirements. Whereas in the US, what we're really focused on now are mainly these opt-out rules under US state privacy rules. And lastly, in terms of enforcement, we've spoken about this already, but we have these individual DPAs within the various EU member states who are responsible for enforcing the GDPR, whereas under US state privacy laws, we're really looking at the relevant state attorneys general. And in California, we also have this new dedicated agency that's responsible for rulemaking and enforcing the CCPA. It's called the California Privacy Protection Agency. And one thing to think about is that the European regulators act independently, but there is this effort to be coordinated, both in terms of harmonized approaches and creation of guidance, but also in terms of coordinating where there is cross-border processing. And we don't necessarily see that same approach being taken with this patchwork of rules in the US. Paul, did you want to mention anything on that slide?
Yeah, but in very briefly as well, because I see there is a question from someone asking whether there is any consideration on the US laws for information that may not be personal or sensitive on its own, but when analyzed as part of a big data set could be. So I would say, that there are two things here, right? Because in relation to personal information, you do have a very broad definition, for example, under the CPRA, where it does say, just like you have under the GDPR, that any information that identifies, relates to, describes, or is reasonably capable of being associated with someone or the household, that is personal information under the CPRA. So it's you have a very broad definition as a result. However, in relation to sensitive personal information under the CPRA, you don't have such a broad concept because you have a list of information which is set out, and if you have information which is not on the list, then technically it would not be considered sensitive personal information as defined by the law. But it doesn't mean that you don't need to protect the data. Most likely, well, it would be personal information under the CPRA, and it does mean that you would have to to ensure sufficient level of protection. And depending on the sensitivity, it does mean that the level of protection may differ as well. So going back here, in relation to enforcement trends, lots of things have been going on. From a US perspective, cybersecurity claims have tremendously increased as well, because you do have quite a number of enforcement actions and litigation as well, which have been initiated by individuals who, as a result of a data breach, have claimed that, well, the company didn't do enough to protect the information. So the cybersecurity claims is a hot topic. BIPA litigation as well in relation to biometric data. A lot of that has been going on because of this Illinois law in relation to biometric data, which does provide as well the possibility for fine, and that's the reason why you see that a lot. Wiretapping and VPPA claims. So that's a recent trend which has appeared in the US, because you have quite a number of plaintiffs which have brought up wiretapping claims, or even brought up the Video Privacy Protection Act in relation to to online content. So they're essentially claiming that, well, because some websites are keeping track of the usage of the website, there is some recording going on of the interaction on a website. So the plaintiffs are claiming that, well, this is a violation of the state's wiretapping laws, and also the VPPA in some cases, for example, in relation to the use of pixels as well to monitor and to keep track of what the user is doing. They're claiming that, well, especially in relation to video content which is being played, they're claiming that this is a violation of the VPPA. I think it's it's a recent trend which has been going on, and it's also a bit of an uncharted area, because obviously those laws, the wiretapping laws and the VPPA law, this federal VPPA, it wasn't introduced at the time, to cover this situation. So you do have a lot of plaintiffs who are trying to broaden as well the scope of those laws, and with some level of success as well, because the cases have been going on for a while, and there seems to be more and more cases as well. So it is something to be mindful of. Selling and sharing of personal information. This is in relation to California law, the CCPA. You have quite a number of enforcement actions as well, which have been brought by the California Attorney General. Most of them have not been publicized, because under the CCPA, you have this 30 days right to cure, by which companies had 30 days in order to fix things. And if they have fixed things to the satisfaction of the Attorney General, then the case would be closed, and then no enforcement action would take place. Unfortunately, there was one company, Sephora, who, according to the Attorney General, did not fix things within the 30 days, and that's why you have this case whereby the company was fined, if I recall correctly, $1.2 million, and they were required as well to provide more information in relation to the selling of information, and as well enforce providing the ability for users to opt out of the selling of personal information. This requirement has been expanded as well under the CPRA, because now it's no longer just the selling; it also covers the sharing of information for targeted advertising purposes. And another important point to note as well is that the 30 days right to cure under California law no longer exists. So now the Attorney General or the California Privacy Protection Agency, they can, if they choose, they can still provide 30 days if they want to, but it's more a discretionary possibility for the authorities. It's no longer a requirement under the law. And then in terms of the enforcement trends in the EU, was this something that you wanted to cover, Richard?
Just very briefly, I mean, in the EU, we've seen increasingly large fines being issued, many of them levied at big tech and very household names. We've seen issues around data breaches, but also e-privacy violations around the use of cookies. We've also seen particular enforcement in the digital advertising space and concerns around the collection and use of things like children's data and biometric data. And we're also starting to see regulators pay attention to some of these emerging technologies. So very recently, we saw the Italian authority take action against OpenAI in relation to the ChatGPT service. So there's a broad range of different issues, including the use of new technologies, and all of that also at the same time, the perennial topics such as direct marketing and other kind of violations as well. So really, there's a whole basket of different trends that we're seeing in terms of enforcement. I think now, just conscious of time, and the other things that we wanted to talk about today are issues around transatlantic privacy and particular international data transfers. So what we're going to spend a little bit of time talking about now is the European rules around international transfers, in particular how they relate to transfers of data from the EU to the US, and looking ahead to some of the developments this year and what is continuing to be an evolving topic. So let's just touch base quickly on how the GDPR treats international transfers of data. Some of you might have certainly read about some of these restrictions, and some of you might actually be familiar with the rules, but just to level set. So the GDPR doesn't actually prohibit transfers of personal data outside of the European Union. It doesn't have a data residency requirement, but it does impose certain conditions when data is transferred outside of the EU. And that's really to ensure that the level of protection that's afforded to personal data under European law travels with the data once it actually leaves the jurisdiction and goes to other countries. And what are the conditions that apply? Well, there are several different conditions and they're all alternative. So you basically just have to satisfy one of these conditions to enable that transfer. One is that you're transferring the data to a country which benefits from an adequacy decision. This is effectively a determination by the European Commission that that country does afford an essentially equivalent level of protection to that guaranteed under EU law. And currently there are about 14 countries, I think, that benefit from an adequacy decision. Most recently, Japan and South Korea, they both have adequacy, and the UK following Brexit, the UK has adequacy as well. But really, it's a limited number of countries, and it doesn't at the moment include the United States. The other kind of bucket of conditions are transfer mechanisms. So they include the standard contractual clauses. These are form agreements that need to be signed by the party that's exporting the personal data, the data exporter, and the party that is receiving or importing the personal data in the non-EEA country. And the data exporter and importer basically sign this standard agreement, and that includes a whole range of commitments, warranties, and representations about how the data will be handled once it's transferred. The European Commission adopted a new set of SCCs in 2021, and they're based on a modular format. So effectively, you select the different module of clauses depending on whether the data exporter and or the data importer are acting as controllers or processors, depending on the scenario. Another mechanism are binding corporate rules. In practice, only a short list of companies have actually adopted binding corporate rules. It's effectively a mechanism for multinational companies to receive and process personal data in compliance with the GDPR. To obtain binding corporate rules requires the approval of an EU data protection authority, and it's a process that can take a number of years and is taking more and more time at the moment. So relatively few are actually in a position to actually obtain BCR. We also have codes of conduct as another mechanism, but again, only, I think, Paul, am I right in saying that only one code of conduct has been actually approved, and only recently? So that remains a pretty rare, a rare use case. And finally, apart from these transfer mechanisms, there are also certain derogations or exceptions that permit a transfer as well. And they include things like if you have obtained the explicit consent from the data subject to transfer their data outside of the EU. But what's clear from guidance is that these derogations should only be relied on in very particular narrow circumstances and should not be relied on for routine transfers. So out of all of these, basically, if there isn't an adequacy decision that you can rely on, most times you're looking at the SCCs as the most commonly used mechanism to transfer personal data under the GDPR. Very briefly, you probably were well aware that in 2020, there was this landmark decision from the highest court in the EU, the Court of Justice of the European Union. And effectively, it was concerned with the Privacy Shield. And the Privacy Shield was a mechanism for US organizations to receive and process personal data. It was effectively a partial adequacy decision for the US, but only in relation to participating organizations that self-certified to the Privacy Shield framework. In 2020, it was invalidated through this claim, the famous Schrems II decision. And really, that was based on European concerns around US government surveillance under laws like Section 702 of the Foreign Intelligence Surveillance Act and Executive Order 12333, which effectively provide a legal basis for US government authorities to access and surveil and conduct signals intelligence activities. So based on that, that caused a huge issue really for organizations that are looking to transfer personal data to the United States. Not only because the Privacy Shield no longer could be relied on as a mechanism, but also because it raised serious questions and concerns about the level of protection for the data once it be transferred to the US, including when you're relying on other mechanisms like the SCCs. So where are we today? Well, since that decision 2 years ago, a lot of companies have been grappling with this issue around how they can lawfully transfer data to the United States, because they have to complete what's called a transfer impact assessment to determine whether they can do that lawfully using mechanisms like the SCCs. That's a compliance burden that's been quite difficult to meet, and that's because the guidance and indications from the EU data protection authorities is quite conservative on the issue. And really, the point being made is that, in fact, because of these surveillance issues, those transfers are very difficult to defend and justify from a legal standpoint. And that's led to a number of decisions from authorities looking at particular types of transfers, effectively ruling that those transfers can't take place. So we've had a number of decisions around the use of Google Analytics, also recently around the use of the Meta tracking pixel, and data protection authorities stepping in and saying that transfer can't take place. You can effectively no longer use those services because they involve a transfer to the United States. But we potentially have a big change this year because we have yet more changes around transatlantic data transfer mechanisms. And that's because we have a potential replacement for the Privacy Shield as a new mechanism to enable those transfers in the form of the EU to US data privacy framework. And I think, Paul, you were just going to spend a few minutes giving our audience an update on what that framework is.
Yeah, absolutely. So you have this new framework which will come in, which will come in the near future. We have, for example, we do have some documents which have come up. So you do have, for example, the executive order from President Biden, which includes enhanced safeguards for U.S. intelligence activities, which has already been issued at the end of last year. And then we do have the updated data privacy framework principles, which have, which are also available in draft form, and we do have an adequacy decision in draft form, which has also been prepared by the European Commission. So there are quite a number of different documents. Many of them are still draft, and the expectation is that in the next couple of months we're going to be able to have a final set of documentation in relation to this, and this would be the replacement to the previous Privacy Shield framework, which was invalidated. Going on as well, because I'm conscious of time. If we move on to the next slide, yeah, we do have this executive order, which was issued at the end of last year as well. It does provide as well quite a number of different safeguards, as I mentioned, and this will be helpful as well for companies who are exporting data from the European Union to the US. Because in many cases, following the Schrems II decision, you have companies who are struggling to complete the transfer impact assessment, which were requirements since the Schrems II decision. But then this executive order would help to facilitate things, because it does include those safeguards which have according to the European Commission, it does address, the concerns as well, which have been raised. So it is something to, to be mindful of. So if you go back to the timeline as well, in May or June, that's when we should expect to see we're already in May, so in June, maybe later this month, but then who knows, maybe it might be July. We should expect to see as well, the final set of documents. Going forward to the next slide, the certification. So if organizations wish to take part in the new data privacy framework and benefit as well from this adequacy decision which will be issued, it's a self-certification process. So it means that organization must self-certify commitment to comply with the various data privacy framework principles, which are listed here: notice, choice, accountability for onward transfers, security, data integrity and purpose limitation, access, recourse, enforcement and liability, supplementary principles. So those, those principles, they are extremely similar to what already exists under the Privacy Shield. So organizations who are already a member of the previous Privacy Shield shouldn't have any, big challenges or whatever to move on to the new data privacy framework because of the similarities. So I mentioned self-certification. You have to commit to the principles, and means that you have to update your privacy notice to mention data privacy framework principles if you do choose to opt into this framework. Enforcement as well would be by the Federal Trade Commission, the FTC, and the Department of Transportation. And then in relation to complaints, individuals may submit complaints to participating organizations, and they would have access to an independent dispute resolution mechanism. Going forward to the next slide. Once if you do decide to opt into the new data privacy framework, then you would be able to freely import personal data coming from the European Union to the US without the need to rely on any other data transfer mechanism, the SCC, for example. You won't need that anymore. And it does also mean that you won't have to worry about the transfer impact assessment as well because of the adequacy decision. Organizations who have already who are already a member of the Privacy Shield framework and who have kept it, who have maintained the certification, they are able to to step into the new framework simply by self-certifying the commitment to comply within 3 months, or otherwise, if they choose that they don't want, for whatever reason, to opt into the new system, they would be able to to withdraw. But then the withdrawal doesn't mean that you don't have to do anything anymore. There will still be obligations as well in relation to data that you have collected and that you are using under the previous Privacy Shield framework. So the withdrawal process is not just a question of sending in a form and then you don't have to you don't have to do anything anymore. That's not the case. You actually do need to to continue certifying that you will abide by the Privacy Shield principles in relation to the data that you have collected previously. And there will still be a fee as well, which would be payable. So I mentioned 3 months, but then the 3 months hasn't started yet. If I'm, correct me if I'm mistaken, Richard. But then the 3 months hasn't started yet because the new framework hasn't begun yet. But then
it would be within 3 months that the framework becomes effective. Yeah.
And once it becomes effective, then the 3 months would begin. You have here on the slide the link to the FAQ on the Privacy Shield website, so you can look at that for further information on the new data privacy framework.
Yeah. I think, Paul, that's probably a good time to finish the presentation. We've just passed the top of the hour, so we're slightly overrunning, but that's just to give you an overview of some background to the issues around data transfers, but also looking ahead to some of the new developments that are going to be impacting organizations in the EU that are hoping to transfer personal information to the US, and also US providers that want to certify and sign up to the new data privacy framework, which will enable much smoother contracting, deals, and provision of services, because effectively that transfer of personal information can take place freely and without additional compliance considerations and headaches. So hopefully that provides a much smoother path for some of the issues that we've been discussing as privacy attorneys over the past few years. If anyone still has a little bit of time, and we appreciate people might need to get off for a call or the rest of your day or afternoon, but I noticed, Paul, there's one other pretty interesting question in the chat as well around targeted advertising. I don't know if you've had a chance to look at that. So we got a question around the opt-out rules under US state privacy laws like the CCPA. If somebody opts out from the sale or sharing of their personal information, does that mean that the organization can effectively still continue to collect information from that user in order to deliver advertising? Or is it simply restricted to situations where they are sharing that information with third parties for advertising purposes? Paul, do you have a thoughts on that question?
Yeah, in relation to to this point, it really depends on how the advertising is being structured, because what the CPRA says is that you cannot you cannot sell or disclose the information that you collect if the individual has opted out. It doesn't mean that you cannot collect for your own purposes the data. So this means that in effect you will still be able to display advertising, but then the advertising may not be personalized anymore in the sense that you're not able to pass on the information to the third party if the individual opted out, but then you can still display advertising on the website.
Yeah. And it's worth mentioning that these rules around sharing of personal information, they are primarily concerned with cross-context behavioral advertising. So that really means where somebody is being targeted with advertising based on their activities across different websites and services. So that's effectively, the ad tech industry where data is shared with third parties through the programmatic advertising chain, and based on their viewing habits and the types of websites and services they interact with and their interests, somebody is receiving targeted advertising. These rules are less concerned with pure first-party advertising, where that targeting is based purely on their use of that single service. But as we know, a lot of digital advertising today is based around this cross-context collection of information. In many cases, that first, the likes of Meta and Amazon, they're able to be extremely effective relying on first-party data, but many smaller websites and services facilitate that targeting through cross-context advertising.
And another point to be mindful of as well is that it's not just California with restriction in relation to targeted advertising. You have other state laws like Connecticut and so forth, who also have their own definition of selling of personal information, their own definition of targeted advertising and so forth. So it does mean that you would have to keep up and monitor closely as well developments in those states. For example, some states may issue regulations as well, and they may eventually decide they want to differ a bit from California law and so forth. We haven't seen that yet, but then it's certainly something which is possible in the next few months, as we reach July, when the new privacy laws are going to be going to enter into effect, and then going forward as well with the other state privacy laws.
Absolutely. Well, hopefully everyone has found that quite interesting and useful topic. You've got our contacts on the deck that will be circulated after the presentation. But thank you so much for joining us today. And I think that closes us out. So from Paul and I, thank you for joining, and look forward to interacting soon.